Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our community conference call, which we do every other Thursday at 12:30 p.m. Eastern Standard Time. And the phone number to dial in is 202 271, no, sorry, wrong, 202 800 8394. 202-800-8394. Let me just make sure that you folks can hear me okay.
The conference is now in conversation mode.
You can all hear me okay, right?
Yes, Raju, we can hear you.
Good, thank you.
We are able to hear you.
The
Excellent.
conference is now in presentation mode.
So when you logged in, you heard some disclaimers that, this is not an attorney-client privileged relationship establishing call, etc. All those disclaimers apply. I'm going to go first over the questions I consider to be frequently asked questions. I think there is 4 or 5 of them today. I'll invite any follow-up questions from you if you have any follow-up questions. And then I'll go over the list of questions one by one and again invite any follow-ups on what I'm discussing. At that point, I'm not asking for new questions, just the follow-ups. If at the end of the conference call we have time remaining, we do this for 1 hour. So if we have time remaining, I'll be happy to answer any other questions. So beginning with the first frequently asked question, this is an interesting one. So here what has happened is a US visa was cancelled without prejudice. So the question is, what does this mean, without prejudice? So folks, whenever you run across a legal situation, this is true for visa cancellation, this is true for litigations. Whenever the authorities, whether it's a judge or the government, says cancelled without prejudice, that means they are cancelling for some technical reason. Without prejudice means this is not going to cause you any harm. So if you want to apply for the same visa again, you can. So this means cancellation without affecting your ability to apply again. So this is not a black mark against you. Whenever something is cancelled without prejudice, it's not going to hurt you. *5. If you have a follow-up question, press *5. Okay, no follow-up question. Let's go on to the next frequently asked question. So this one says, I have an approved I-140 from a previous job. My new employer has initiated the PERM. How can I make sure the attorneys use the priority date from the old I-140? So let's begin by assuring you, first of all, even if your lawyers do nothing to use the old priority date, that priority date is your right anyway. So government itself is supposed to run a data sweep, check their databases, and give you the earliest date you are entitled to. And if they don't, if none of the documents reflect that you've been given the earlier priority date, this is still not a problem. Why? Because you can always attach a copy of the old I-140 approval notice with the current I-140 approval notice, and that is as good as having a date transferred. So there's no other procedure required for you to follow. So you don't have to be overly concerned about the attorneys using the old priority date. Okay, so but typically what we do is, when the PERM is approved and we file your new I-140, we attach a copy of the old I-140 notice, approval notice, and request the government to please assign you the earlier priority date. It is not required by law or procedure to do it, but this is the right thing to do. And if the government for some reason neglects to assign you the priority date, the earlier priority date, that still doesn't mean anything. You are entitled to that priority date by law and by procedure. They can't take that away from you. Okay? *5, if you have a follow-up question on this priority date issue. *5 on your phone if you have a follow-up question. Okay. Let's go on to the next frequently asked questions. So this is a question about what will happen to me once I finish my STEM OPT and I complete my master's degree. So you are in a unique situation because you have all the best signature items going for you. So let's look at two situations. People who were born in India and whose spouses are also born in India, so they can't take advantage of green card cross-chargeability, which means if I am born in India but my wife is born in Nepal, when I apply for my green card through my employer, I can actually use Nepal as my chargeable country. So my green card comes in a year and a half to 2 years instead of 10 years or 15 years. So if you are not chargeable to any country other than India, you are stuck. You still have the best situation possible. First of all, you'll have 3 or 4 tries to get through the H1B lottery. How? First, you will have the regular optional practical training, then you'll have the STEM OPT extension. So you have the STEM degree, that's great. So you've got 3 years to do this. Okay, 3 tries. Second, under the current system of lottery, people with master's degree actually have a higher chance of getting selected in the lottery. I don't know exactly how much higher. I think it was something like, I could be wrong, but I think it was something like 18% better chances, which is almost 1/5 better chance. And it looks like that should work out for you. Now, what happens if in 3 years you are still not able to qualify? It happens. It happens very rarely, but it happens. Many people end up going back to curricular practical training and go back to school for another degree and work and study at the same time. So those are the only options, unfortunately, for people who are chargeable to India. Okay, let's see what other questions. Also, another thing is, oh, please don't call me Rajiv, sir. Just Rajiv is fine. Another thing is that you don't know what the laws are going to be or the procedures are going to be in 1, 2, or 3 years. Congress is keenly aware of the perceived shortcomings in the H1B process. Things might change by that time. Nevertheless, what other choice do we have? It appears to me that having 3 tries through STEM and having a master's degree improves your chances. *5. If you have a follow-up question on this, press *5 on your phone. Okay. Let's go on to the next frequently asked question. This one is, H1B visa holder travels abroad for work sometimes. Is an H1B amendment required for change of address or location? So if you Google my name, Rajiv S. Khanna, Economic Times, you'll see my articles in the Economic Times, and one of these articles talks about working from abroad while you're on H1B. The bottom line is, there is no law that requires you to have an H1B if you are working from a country other than USA. Now, if you go to Canada and you're a citizen of India and you don't have any work visa in Canada, you'll probably need a work visa in Canada. But sitting in Canada, you could work for a US company. I don't see any problem with that. It's a little bit more intricate. I want you to pull up that article that I have written. It should also be on my blog. So if you go to immigration.com and look at my blog, it tells you what you should be doing. But also remember, 1, there is no law that requires you to have an H1B if you're working from outside the United States. And 2, I'm trying to remember, hang on, there was a second point I wanted to make. So you're working from outside the United, oh yes, there is a kind of visa, H1B visa, called intermittent H1B. What does that mean? That means I live in USA, I live in India or any other country, and I come to USA only 15, 20 days a year or 6 months or 3 months, whatever time I want to be, less than full-time continuous. That's called an intermittent H1B. So that's even allowed under the law. I don't see any problem in working from abroad and coming to the USA intermittently. I think that's perfectly fine. *5 if you have a follow-up question on this. *5. Okay. Oh, there is a follow-up question from Connecticut. Yeah, Connecticut, go ahead, please.
So, what I meant to ask is there an intermittent L1 visa as well?
Oh,
On the
absolutely.
similar lines?
Oh, absolutely. Absolutely. You know, we have so many clients who are global CEOs and they come to the United States only 10 or 15 days a year. But because getting tourist visas and business visas is so hassle-some, they just have L1s. So they come only 15 days a year, but they still hold an L1 visa. That's perfectly okay. All right?
And does it have a validity? Because the L1 lasts only for 7 years maximum.
Well, if
is there a separate validity for intermittent L1?
Yes, because anytime, I don't remember the rule exactly for L1. I'll tell you the rule that I remember and what I remember for sure. For H1B, anytime you are in the USA less than 6 months, you get the whole year back. I believe it's the same rule for L1.
Beautiful.
That means that L1 could go on forever and ever and ever. Okay?
Beautiful.
All right, so that's how it works.
Beautiful.
All right?
Beautiful.
Good luck.
I'll need to connect you over that sometime later after the call.
Sure, no problem. You can email me to help@immigration.com. Help@immigration.com. Okay?
Beautiful. I'll do.
You're welcome. You're welcome, sir. Okay, next question. Oh, they still have something left. There's another. Oh, there's. Did I just answer Connecticut question? I don't know. Let's just. Yeah, it is done. Okay. Now, no other questions, but there's another part to this. It says my base work location is our Detroit office. I live in Windsor, Canada. I can cross over to USA when needed. Oh, no, your home is in Canada. I don't see any need for you to do any amendments or anything. Okay? So you are fine. I don't see any problem. But do read my article in the Economic Times. I don't see any problem, okay? Let's go on. Okay, so all the frequently asked questions were answered. Let me go into our regular questions. Where do we start? Okay, here we go. So this one is changing job before 180 days of getting I-140. How will I know if my previous employer has revoked my I-140? So the only way you can know, or the best way you can know, is to contact your lawyers. In most states, or at least many states, lawyers who represent the employer automatically also represent the employee in immigration cases. Okay? So ask the lawyers, have you been instructed to revoke my I-140? And if they haven't, I would still double check with my employer also if I were you. I'm not very comfortable with relying upon the USCIS information on the screen because that information is notoriously unreliable, especially in older cases. So you can also try calling them. They may not give you that information, but I think the best way to find out is to contact your employer and lawyers. Another thing you can do simultaneously is file a Freedom of Information Act request. So you can Google this, Freedom of Information Act request USCIS. It doesn't cost you anything. This way you can get a copy of all your documentation from the USCIS. *5, if you have a follow-up question on this, press *5. Okay, this is from area code 682, which is Texas. Texas, go ahead, please. I can hear you.
Yeah, are the only two options checking the lawyer and then raising the Freedom of Information Act?
Yes, sir. No, you can.
Is there any further
No,
option?
I said 4 things. Excuse me. 4 things you can do. 1, call the lawyer. 2, call the employer. 3, file the Freedom of Information Act request. And 4, call USCIS also. Okay?
Mm-hmm, mm-hmm.
Those are
Yeah, in USCIS there is an automated call which says that it is approved. So does that mean that it is approved, or do I need to talk to a representative?
it is approved, but we are concerned whether it is revoked or not, right? So approved is fine, but was it
Right.
subsequently revoked?
Mm-hmm.
That's why you need to contact somebody live. Okay?
Okay, okay. Mm-hmm, mm-hmm. Okay, yeah.
Good luck to you.
Thanks a
Sir.
lot, sir.
Oh, you're welcome. Let's go on to the next. Okay, that one is done. So this one is number 3. H1B petition is under process. My spouse's place of birth is wrong in the passport. Will it be a problem during visa stamping? So what is the place of birth? You can go for the stamping, and if this issue comes up, you can let them know that you are taking steps to correct this. I don't think this is going to be a problem because she has a valid passport. At the H4 stage, that's all they are looking for, a valid passport. They don't go into the details of whether the place of birth is right or wrong. I don't think that should be a problem. Okay? Star 5 if you have a follow-up question. Star 5. All right. Next question. Javier, there is an error caused by USCIS on the green card. So one is EB3, one is EB2. Yeah, you should attempt to correct the category. You no, don't submit the I-90. Don't do that. There is actually an online process. So what you do is Google. Let me double check if that comes up. USCIS typo. Yeah, USCIS typographical error. And you come to a URL egov.uscis.gov e-request display typo form. So just go through typographical error, the form. I think that should work. Okay. Star 5 if you have a follow-up question on this. Star 5. Okay. This one is area code 501. There are 2 questions, one from Arkansas and the other one is from Wisconsin. So let's do 501, area code 501 first. Go ahead, sir. 501.
Hi, Rajiv.
Yes.
Jay here.
Uh-huh.
Actually, is it just a typographical error, or they approved in that category? That's the confusion I had.
Well,
So
you know,
when they approved, my priority date was not current.
yeah, I've seen so many of these cases. I would say at least 50 to 100 cases I've seen like this. And I think you have to ask them to correct because I don't know how it'll work out. At least for you, it is a typo. Just tell them it's a typo. Now they might say, well, we approved in error. You don't have a green card. Your wife doesn't have a green card. Then they should put you back in the 485 queue. I don't want you to be in a situation where you get the approval and then 5-6 years later when you try to get naturalization, they say, oh, sorry, you don't even have a green card. And they've done that to other people.
Oh my
So,
God.
yeah, try to get it corrected. But don't get concerned. This is not your problem. If the government is too pushy, you can push them back. Don't worry. That's why the good Lord made courts for.
Okay.
So don't worry, okay? Just try the typographical
Actually,
system.
I have a plan. Yeah, I have a plan to travel, so I'm
Oh, traveling is fine.
Submitting I-90.
That don't worry about. Yeah, that's why I'm saying submit the typographical error form, but you can travel. And by the way, even if you submitted the I-90 and submitted your green card, you could get a stamp on your passport from the USCIS using InfoPass. They'll stamp your passport. It's called an addit stamp, ADIT. The addit stamp is as good as having a green card. You can travel with that. Okay?
Okay, Rajiv.
Good luck.
Thank you. Thank you.
You're welcome,
Yeah,
sir.
good luck. Yeah.
Okay, so then, We have one more from Madison, Wisconsin. Wisconsin, go ahead, please. I can hear you.
नमस्ते राजीव जी मैं
नमस्ते।
राहुल बात कर रहा हूँ
अरे
हम
अरे
लोग
हाँ,
बात
राहुल,
कर
how are
चुके
you?
हैं mine is similar but different situation so I already submitted congressman's inquiry because so should I wait to submit
Yeah.
this e-request
Yeah,
until
you
I
should
hear back from the congressman?
definitely wait. Definitely wait. Okay.
Because I don't want to do too many things
No.
at the same time to, to force them. Because I have read on many forums and even some other attorneys have said that in some cases USCIS is using their discretionary authority to do these kinds of things. So, I mean,
I
it's
disagree.
not necessarily illegitimate.
I disagree. There is no discretion here unless they are changing the law and policy. Well, look, it's in my favor. I will take it, but they don't really have the authority to do that. Okay?
Right. So maybe wait until the congressman gives something
Yeah.
back and then take
Exactly.
any next steps, I
Exactly.
think is what-
Wait. Okay?
Okay.
Good luck.
Okay. But I cannot use the green card for
Sure.
anything
Why
until
not?
then, right?
Why not? You can use it to travel as long as it is still not revoked. You can still use it. Why not?
Okay.
All right.
Okay. Interesting.
All right.
Okay. But then what happens?
I gotta go,
if you
Rahul.
use it and then-
Rahul, I gotta go.
Thank you.
Good luck. Okay, folks, just to remind you, don't ask me any new questions. Only follow-up questions on what we are discussing. Rahul was asking me follow-ups, but we were taking a little bit too much time. So I have a little limited amount of time. I want to cover as many people as I can. So no new questions right now. Virginia, area code 703. Go ahead, please.
Sir, I have a very quick question too regarding the same thing. Thank you so much. Regarding EAD, we tried the congressman, they refused, and then we called USCIS. They picked up the phone. They said, you'll get a reply in 72 hours. We never got one. So is there any other procedure, anything else we can file, or this is only a waiting process nowadays?
What have you done? Have you filed your I-90? Is that what? What have you done?
Yes, I-90 10-year renewal for my mother. She's 77. Yeah.
Does she need
10-year green
to?
card
She needs to
renewal.
travel, right? That's what you're saying.
Yes, next month. Yes, sir. So USCIS, they picked up the phone. They said we'll get a call in 72 hours.
Okay. I would
Now they say you're in the queue.
I would open a ticket with the Ombudsman's office also. USCIS Ombudsman's office.
What is it?
Ombudsman.
How do you spell it, sir? Ombudsman?
Yeah, in India we used to call it Lokpal. So Ombudsman is Om as in Om, buds,
Okay.
buds as in flower buds, BUDS, man as in man woman,
Okay.
Ombudsman. Okay.
Okay.
So just Google USCIS Ombudsman. You can open a trouble ticket.
Okay.
Ombudsman is an independent office within Department of Homeland Security that supervises the shenanigans of USCIS. And they report to Congress.
Yeah.
Okay?
Okay.
Good luck, ma'am. Okay. So let's see. Next question. This is from Adi. H4 cap exempt approval rate for a person who worked for 10 years, L1A plus H1 in the US. Am I considered cap exempt if I worked on a L plus H for 10 years between 2009 and 2020? And you have an I-140 approved? Yes. If your I-140 is not revoked, you are still cap exempt. I think you already asked me that question. *5 if you have a follow-up question on this. *5. So we did the frequently asked questions already. Now on to question number 8. Oops. Oh, what did I do? Question number 8. Sorry about that. 4, 5, 6, 7, 8. Being on H1B visa, can I take unpaid or paid leave for a couple of years? Oh no. Only medical reasons. If you have some protracted, heaven forbid, problem, and you can bring in medical certificates or doctor's letters, hospital bills, etc., you can't be that long on H1B on an unpaid leave. But you can go to school simultaneously with your job. So there's nothing that stops you from doing that. Okay. Then the question is, can we change job requirements after a prevailing wage determination is filed but not yet approved? So I'm not sure if you're asking in the context of PERM or H1B. In both contexts, if the job description changes substantially, you have to start all over again. That prevailing wage is only good for that particular job description. Okay. Star 5, if you have a follow-up question. Star 5. All right, let's go on to number 9, we already did. Number 10, L1 to H1B change of status and retaining L1B status. I currently work for a US company on L1B. Another employer filed H1 in June. H1B is approved with a change of status. No, October 1st, you will be automatically on H1B. You will no longer be on L1. So if you want to convert back to L1B, you have, a few choices. If you already have an existing L1B visa, you can travel outside USA, come back showing your L1B visa, L1B approval, and CBP will convert you back to L1. They'll just give you an I-94 that says L1B. That's a conversion. Second option is to actually apply for H1 to L1B conversion through the USCIS. So which is like filing an L1B all over again. Okay. That's how you retain your L1B status. Star 5, if you have a follow-up question on this, press star 5 on your phone. Okay, no questions. Let's go on to number 11. No movement on the application at Nebraska Service Center. Should I file I-485J or file a new I-485? So you did an EB3 downgrade. Dates are current. So what the government is saying is, and they have a frequently asked questions released yesterday also, they are saying is that don't do anything, be patient, wait. You have already applied for new I-140 EB2 with transfer of underlying basis. I guess filing I-485J should be okay. Are you on the phone? Press star 5 if you're here. I have a quick question for you. I'm not sure I understand this situation completely. Okay, you're not here. So you filed for an EB3 downgrade, but have you filed a 485 yet? When you're saying filing a new I-485, I'm assuming that you have a 485 pending. And if you do, and you have not yet filed a 485J, and you are converting back to EB2, you should definitely file a 485J. And file it at that particular address, the address that the USCIS has developed only for this purpose. So yes, that's what I would recommend. Star 5, if there is a follow-up question on this, folks, star 5. Okay, next question is effect of divorce on an employment-based case and cross-chargeability. So since you already have your green card, I don't think cross-chargeability has any impact anymore. Now, what if you got divorced while your green card was not yet approved? Well, I don't know the answer to that question, but I can tell you this, I am concerned that because you lost your right to cross-chargeability before your green card was approved, this could become a problem for you. You should have this researched. Because divorce or legal separation both can be a problem potentially for cross-chargeability. It should be examined very carefully. *5, if you have a follow-up question. Yeah, and this could become an issue for you at the naturalization stage also, because your green card is improperly approved. So please follow this up. Next question is, can I apply for an H4 dependent visa for my spouse? H1B is about to expire in a couple of months. I think it'll be difficult. Although I'm not sure that there is any legal requirement that your H4 visa or H1 visa should be valid. But why don't you just wait for an extension and then send her the paperwork? You are planning your wedding in February. It'll be April by the time she gets her H4 visa. I have my H1B approval till June 28, 2023. Oh, so you can't get an extension. If you're, talk to your lawyers. If your labor certification PERM was filed more than a year ago, you can get a 1-year extension of an H1B 6 months ahead of your current H1B expiration. So your current H1B expires, let's see, June. So that means in January of 2023, if you have arrived at that 1-year labor cert pending mark or labor cert filed mark, you could get a 1-year extension filed in January premium processing. When you go for your marriage, you by that time or soon thereafter, you will get 1-year extension, and that way it removes the problem altogether. That's what makes sense to me. Okay. *5, if you have a follow-up question. Okay, I think we have covered all the questions. Let me lock our conference so that we can cover all the new questions now. Give me 1 second. There is a follow-up question. I'll get to that. Just give me 1 second. Let me lock the conference.
The conference is now locked.
Okay, so we have a question from area code 608, which is Wisconsin. Wisconsin, go ahead, please.
Sir, मैं फिर से राहुल बात कर रहा हूँ, and I did wait until everything was done. I mean, every other question was done. So, to continue my question,
I am not sure I can entertain you right now, Rahul. Rahul, sorry. I have to call in for new questions. Okay. Put in your question. I'll attend to each question in the order that they logged in. So stand by. Okay. So folks, anybody who has any question, press *5. I will talk to you in the order that you logged in. Okay. Anyone has any question, press *5. So Rahul, there is only one guy ahead of you. No, 2 people ahead of you, 3 people ahead of you. And 1 person behind you. So there's a total of 5 people with new questions. Let's attend to them 1 person at a time. This is from California. California, go ahead, please. I can hear you.
Yeah, hi. Sir, my name is Vinod. Actually, the thing is, I have applied a downgrade EB2 to EB3. 2020, I received the EAD.
Right.
Long time. And in this June 2022, also I have applied for EB2 because my date is current now.
Okay.
So all my fingerprints been applied from EB3 to EB2. Okay. Now the case everywhere it says that the fingerprinting be applied. So my 2 questions here is can I use my EB3 EAD and AP, one to travel and one to go for a new job? Will be considered as a EB3 or it will not have any effect on my EB2 education?
So government, USCIS, in a conversation with American Immigration Lawyers Association said, we don't mind you using your EAD or AP even when the transfer of basis is pending. This information is on immigration.com in my blog. you'll see the first 5 or 6 entries. This information is reported there. You should be able to use your EAD and advanced parole. And it doesn't matter.
Okay.
Yeah, so
Okay.
even still you can transfer your basis. What else?
So I will be, and I'll not be on my H1, right? So status will be EAD, correct?
Yeah, if you use your EAD, then you are on EAD.
Or my H1.
Well, if you travel, is that what you're
And
asking?
if I want to come back on...
Hang on. Are you saying...
No, sir. I want to do two things.
If you change employers...
One, I want to shift on EAD and work on it.
Yeah, then you will be on EAD, not on H1B any longer, sir.
Okay. And if I travel and come back on AP, still I'll be on my EAD, correct?
If you travel, come back on AP, yes, you'll still be on EAD. Yes, correct.
Okay. And in case anything happens to my 485, if I want to come back to H1, what is the process, sir?
If you have time remaining on your H1B, you will apply for an H1B like any regular person. You may have to go outside for visa stamping, but you will apply for an H1B. Okay. Good luck.
Okay. Thank you, sir.
You're welcome.
Thank you, sir.
You're welcome. So there's a total of 6 people with questions. Now there's 5. Let's go to Connecticut. Connecticut, go ahead, please.
Yes, hi. So I have a I-797A that has an approved L1A petition. Now, I was out of the country and having difficulty getting the visa stamped because of the delays at the consulate level. Now, I'm in Canada right now, though I'm eligible for a Dropbox, but I cannot get the visa stamp. Now, is there a provision on the CBP that would permit me entry with penalty, if required, to enter on a valid I-94 that is valid up until 2023? And
hang
the
on.
approval notice 797A.
Hang on. Are you a Canadian citizen?
No, I'm not a Canadian citizen, but I'm in Canada on a work permit.
Okay, no, there is no such provision. You have to get a visa stamp. Okay?
There's no way to work out
Nope.
documentation.
Nope. You can go to a 3rd or a 4th country. You can try getting an appointment in Mexico, Jamaica, Bahamas, Costa Rica, any of these neighboring countries. You can try to get an appointment there, but you cannot enter without a visa on L1A. All right?
I understand. So would your office be helpful to guide me? I could engage, and if
there isn't.
Would your office be able to guide me better on?
There isn't anything for us to do. What I told you is what I would tell you even if you paid for my time. I would just tell you, go to the State Department scheduling.
I appreciate it. I really appreciate this.
You're welcome. So there's nothing for us to do. Just go ahead and make an appointment wherever they can. One thing you have to keep in mind, make sure that they are processing what is called TCN applications. TCN means third country nationals. Because if you go to Costa Rica, you're not a citizen of Costa Rica. So they are going to process somebody from India. That's called third country national. So almost all consulates do it. TCNs have always been around. So I wouldn't worry about it, but double check it, make sure they are processing TCNs. Make an appointment, go to a third country. Okay?
Okay.
Good luck.
Got it. Thank you.
You're welcome.
Thank you very much.
You're welcome. All right, so we are done with this one. We have 4 more questions. This one is from Kansas. Kansas, go ahead, please.
Yes. Thanks, Rajiv, for taking the call. Quickly, right, I have filed for I-130 for my sibling. It's been more than 11 years, and it's showing, the current status is showing like 140 months for California. And my question is, if my sibling is here, can I file for I-485 for his green card or not?
Well, if they were here on a kind of visa that does not conflict with filing a 485, number 1. And number 2, their priority date was current. Is it current? Do you know?
I don't know. I'm just checking the status. It just shows 148
Okay. No,
months.
what you
That's
do
all I can
is,
see on their US.
okay, you're sitting at a computer right now, right?
Yes.
Okay. Go to the search engine, whichever one you use, type Visa Bulletin.
Hmm.
Tell me when you are there. Do you see the very first entry, Visa Bulletin travel.gov?
Hold on.
Visa Bulletin.
Visa. The first is the Visa Bulletin Travel Gov. Yes.
Yeah. So you see that entries for September 2022. Click on September 2022.
Okay.
So this opens the Visa Bulletin. This tells you which people can file 485 in September. Okay. So you said this is your sibling, right? Your brother?
Yes.
Okay. So that, if you'll see, that's on the very top, it tells you that's fourth category, family preference 4, F4, right? So when you scroll down, scroll down, F4 for India-born people in the table shows they are currently processing 15th September 2005. So anybody whose I-130 was filed on 15th September 2005 or earlier, they are entitled to file 485. That's just the rough, that's not the only way to look at it.
I'm from Nepal. I'm from Nepal. So
Okay,
how do I
so then you look at the rest of the world. All chargeability areas except those listed. So that's the first column, and that is at 22nd March 2007. Only 2 years, only 2 years better, not too much. So people whose cases were, whose I-130 was filed in 22nd March 2007 or before are eligible to file 485. So this comes out every month. You can keep track here. Okay.
Okay. So if he's visiting with a visiting visa, then he
I would not.
cannot
I
file
would be.
I-485?
I would be very reluctant to advise that, because that can be considered to be a fraud, misrepresentation, misuse of the visa.
Oh, okay. All right. Thank you so much.
You're welcome. Good luck. Okay. Next is Pennsylvania. Yeah, Pennsylvania. Go ahead, please.
Hi, good afternoon, Rajiv. Can you hear me?
Good. Yes, I can hear you. Go ahead, please.
Okay. So I understand that when we have a green card and after 5 years completed, we can apply for a citizenship. And during this time, like within 5 years, say like if I take out of country for 1 or 2 months for a vacation, so all those months will be counted for all the 5 years. And then later on, after 5 years, say like for the 5 years, I go like 6 months outside. So is that means after 5 years, 6 months only I can apply for my green card?
No.
I mean, sorry, for my citizenship.
So citizenship works like this. First of all, you can apply 90 days before your 5th year anniversary of green card. Not exactly 5 years, but actually 90 days before the 5th year. Number one. Number two, you can travel and that does not get deducted from your 5 years. But that can get deducted from your physical presence. So you must have had a green card for 5 years. And you must be physically present in the United States for at least 30 months, 2.5 years. Okay? So that means you don't have to be present all 5 years. You must be physically present in the United States for 30 months. None of your visits should be 6 months or more. And if it is 1 year or more, you lose your green card. Okay? So if you wanted to travel, let's say, let's look at year 1, year 2, year 3, year 4, year 5. In year 1, you were outside USA for 5 months. No problem. In year 2, you were 5 months, 5 months, 5 months. In the 5th year, you were outside for 1 month. So that means you were outside for 21 months in 5 years. you still qualify because you were here for more than 30 months. And none of your visits abroad were six months or more. Understood?
Okay, Rajiv. So, yeah. So one question is like, say like if I change my job, like from my sponsoring green card employer sooner, like within 6 months of getting my green card, due to some reason like salary hike problem or something like a valid reason, and that time that is a good thing. I need to wait for 5 years, then apply, right?
No.
Because
so
the US
if you have your employment-based green card, and you have a good reason to leave the employer after a few months, your 5 years still begins to be counted from the date of your green card approval, not from the date of change of employer.
Okay. But in case if it is not completed 5 years, right, and then with the sponsoring employer, and
you don't have to stay. Hang on. You are not required to stay with the sponsoring employer for 5 years. There is no such law. You can leave anytime you please. There are frequently asked questions on immigration.com on this issue on our website. Take a look at those. How soon can I leave after I get my green card? There is no requirement at all for you to stay 5 years. Not at all. Okay?
Okay, Rajiv. All right.
Good luck.
Thank you so much.
You're welcome. Okay, so we now have 2 more questions. This one is Michigan. Michigan, go ahead, please.
Hi, Rajiv. Good afternoon.
Good afternoon, sir.
So my question is, I have my H1B petition approved, and I'm still on my STEM OPT. But unfortunately, last week I was laid off by Ford Motor Company, and now I have a new offer from the new employer, and I'm trying to convince them to initiate the transfer before October, so that I can have my H1B transferred, and they are willing to do the premium processing. But I have a couple of questions.
Go ahead.
Like just in case if the process gets delayed after the October, is my current employer legally required to withdraw the petition?
Yes.
Because current employer is not withdrawing the petition till October.
Yeah.
But they might or might not withdraw after October 1. So
yeah. So
just wanted to understand, like, are they legally required or not?
Yeah, they are legally required to withdraw the petition, or they are required to pay your full salary. Okay. So the way I would advise my client, if I were advising Ford Motor Company, I would tell them, folks, please withdraw the H1B effective October 1st, but send the letter itself on October 1st. Okay. Or you can send the letter on September 30th. I prefer you send it October 1st. That way, the risk to the company is minimal. Government could, if they ever audited Ford Motor Company, they could say, well, you owe him 1 day's salary. Although I would fight against it, I would say no, because I asked for revocation effective October 1st. I think you are fine. Only time you are in trouble is if the revocation is effective before October 1st. Okay?
Okay, so suppose they are withdrawing on October 1,
that's
and
fine.
now I'm trying to complete the process before October, that is in September. So I have like 30 days
hang
right
on,
now.
hang on.
Yeah.
As long as you get your H1B transfer filed before October 1st, their revocation is not going to affect you. You can.
Oh, really?
Yes, absolutely.
That's great.
Yeah.
Okay, so I mean, as soon as I have the confirmation from the USCIS or the receipt,
right,
the revocation is not going to affect my current.
It is not going to affect you. You can continue to stay, but you cannot work till the approval comes.
Understood.
Okay.
Understood. And in that case, do I need to go out and stamp my visa, or I can just?
You should not have
after
to.
The approval, I can start working
I don't think you should have to, because I would argue,
okay,
because your H1B was withdrawn effective October 1st, you actually have a 60-day grace period to find another job. You actually applied for it before even the period started. So I'm not worried about that.
Okay. And one last question. Are there any chances of getting the RFE or rejection because I don't have the H1B pay stubs?
No. They will ask you about maintenance of... See, RFE doesn't bother me. Successful response to the RFE is my concern. Whether or not I get an RFE doesn't matter. There's nothing illegal about this. Why should you have pay stubs if you haven't started working for that company? So no problem.
Right.
Okay.
Okay. So then I will try to initiate the transfer as soon as possible.
Yes, sir. Good luck. Okay. So let's go on to the last question. This one is from New York. So New York, go ahead, please.
Hi, Rajiv. Good afternoon. Thanks for taking my question.
Good afternoon.
My situation is my wife and I have our own H1s with our approved I-140s. We've been here on H1 for more than 6 years, and it's been more than 6 months that our I-140s are approved. If one of us opts to go for the H4 EAD, is it possible to switch to H4 EAD without breaking our current employment?
Oh, absolutely. Well, hang on. I don't know about breaking the employment because you could have a problem. Why could you have a problem? Because EADs can be taking a long time. So what if you get your H4 approval, but you don't get EAD? Now you don't have H1B, you're sitting at home waiting for EAD. So there could be a break in the employment. Nobody can guarantee that.
Okay. Okay, if that is the case, like let's say we accept that break and then convert one of us to EAD, and later if there is an issue with the primary H1 for some reason, can the other person on EAD go back to H1?
Oh, absolutely. No problem at all. We do it all the time. That's perfectly okay. As long as they have time remaining, well, in your case, I-140 is approved. So it's never a problem. She's not subject to the quota. She can do premium processing H1 anytime and go back to H1.
Okay. Is there any time limit?
No time limit. She can do it 10 years from now if she wants.
10 years on EAD and then ask for H1
absolutely.
Because 140 is approved?
No problem.
Fantastic. Okay.
Good luck.
Thanks, Rajiv. This is helpful.
You're welcome. Good luck.
Yeah, thank you.
Bye-bye. Okay, folks, that's all the questions we had today. It's always great hanging out with you guys. Take care, and I'll see you again in 2 weeks. Bye-bye.